Hi, my name is Jim McGillis. I'm a business and employment attorney in Minneapolis. Today I want to spend a few minutes talking about non-compete agreements and the blue pencil doctrine. First of all, non-compete agreements in Minnesota. Are they enforceable? Sure, at times. There's a standard that courts look to, and that standard is if a non-compete agreement is limited in duration and scope and serves a legitimate employer interest and is entered into correctly, it will be enforced. Now, in Minnesota, we have something called the blue pencil doctrine. What's that? The blue pencil doctrine allows a court to modify or even rewrite portions of a non-compete in order to keep it enforceable. So for today's discussion, the question is, when will a court or won't a court use the blue pencil doctrine? Well, there was a federal case from a few years back called Gavaris versus Greenspring Media. In this case, Gavaris began work for a company as a sales manager. Eventually, he worked his way up to operations and project manager. When he began his employment, he entered into a non-compete agreement. Like a lot of non-compete agreements, this agreement said that for 24 months after the termination of his employment, for any reason, he could not engage in competitive activities, except if the employer had breached its employment agreement with him, he wouldn't be bound by the non-compete. Well, as these things go, eventually, Gavaris decided to leave his employer and went to a new employer. After he began working for the new employer, his former employer sued him in federal court, alleging that he had violated his non-compete agreement. The court looked at his non-compete agreement and declined to enforce it. Why? First of all, they said there were ambiguities in the non-compete agreement. An ambiguity is when there's a confusion in the intention or meaning of the agreement. Ambiguities are typically construed against the party that drafted the agreement. In this case, the employer had drafted the non-compete agreement. So what was ambiguous about it? Well, the non-compete said that so long as the employer did not breach the employment agreement, there would be a 24-month non-compete. Turns out, however, there was no employment agreement. Instead, there was an offer letter. The court decided that an offer letter is different than an employment agreement, and therefore there was an ambiguity. Secondly, there was a date missing from the contract. Again, the court looked at this and was uncertain about enforceability. So the employer said, Judge, use your powers under the blue pencil doctrine to rewrite this non-compete. You can make it more limited. The court declined to do that, however. Why? Because there was no geographic limitation on the non-compete. There was no definition of what a competitive activity was, and there were no notice provisions such that the employee could reasonably be on notice of the scope of this non-compete. So because of those reasons, the court decided they would not, and it would not, bail the employer out by using the blue pencil doctrine. Couple takeaways here. If you're an employer, make sure you have a complete contract with unambiguous terms. If you're an employer looking to prepare a non-compete agreement and offer it to your employees, please contact Jim McGillis at Trepanier McGillis Patina in Minneapolis.